Cruz, and all three of your instructors. We're going to talk about some of the questions that you have posted to us already in the discussion forum thread for questions that has been on the course for a couple of weeks, as well as questions that you type in during the course of this Hangout. So I'm going to let my colleagues introduce themselves. Let's start with Anne.
Hi, I'm Ann Gilliland, UNC Chapel Hill. Exciting to be here with all of you.
And Lisa.
Hi, I'm Lisa Macklin at Emory University in Atlanta. Nice of all of you to join us today, and thanks to Kenny for joining us as well.
Cruz, and all three of your instructors. We're going to talk about some of the questions that you have posted to us already in the discussion forum thread for questions. Okay, we had a brief technical interruption there, but Kenny, I actually forgot to put together a biography of you that I could. So I will let you introduce yourself and just start out by saying that you've been somebody who has taken the lead in teaching copyright to librarians and educators for quite a few years. You're somebody whose work I respected long before I went to law school, and in some ways I hold you responsible.
Oh my gosh.
But I mean that in the most grateful way. So would you like to say hello?
Thanks, Kevin, and thanks, Lisa. Thanks, Anne, and thanks to Rebecca and everybody behind the scenes making this possible. What a pleasure to be here. I'm excited to play a role in all of this, and I'm delighted to have all three of you as colleagues. I think one way to describe what let me introduce myself in a very different way. When I started working on these copyright issues that are of importance to universities, to libraries, to publishers, scholarly publishing, there was almost nobody out there touching these issues. We had maybe 3 people around the country who were dedicating a lot of time to it, and delightfully, one of those is Lolly Gassaway of North Carolina. So, for some reason, North Carolina has been the hotbed of copyright activity, and so that's a good thing. So when I was working on these issues, starting in the late 1980s, the issues were complex. They were bewildering at times, and there weren't very many of us out there touching them. And so I've had the pleasure of working on fair use, ownership, a host of other concerns through a long period of time, while those are very often the same issues that dominate our conversation. We address them in very different ways. Of course, the technology has changed, but more than that, the diversity of work that we're doing, the way we choose to communicate, and the nature of the way we understand the values has changed. And a good indication of that is the restructuring and rethinking of policies at our institutions. I've seen some radical transformation there. The involvement of more people who are aware of the importance of these issues, whereas it used to be a small group inside each institution. Now that's spread out. And I dare say, I'm sure that you've had a lot of conversation in this MOOC about the about recent court cases on fair use. And I dare say that while it's easy to surmise that fair use fundamentally has not changed, I think a lot of the decisions that we're getting from the courts today would not have stood much of a chance of being acceptable by courts 10 and 15 years ago. So we're seeing some very different perspectives about the nature and role of copyright and fair use that in a very subtle way is leading to some important transformations in the law, in the way we work with the law. That really wasn't very much about me, other than to say that it's about what I've seen over the years. And so it's exciting to be in a time of change, and I'm delighted to be here. So let's get to some of your questions.
Well, actually, Kenny, your having said that makes me want to follow it up.
All
And
right.
one of the things we talked about discussing during this time was some of the recent case, the Hathi Trust case, in which we've seen an appellate court decision, and the Georgia State case, in which I know you've been deeply involved, and where we're still waiting for an appellate decision. Would you like to sort of give us an update, tell us your perspective on those cases? I also wanted to ask you, in the same regard, whether you think what's changed for the courts that have made them perhaps more amenable to fair use or amenable to fair use in a different way, is it the awareness of technology that has changed for the courts, or what is it? That's a lot to ask you.
No, that's great. Let me start with the last point first. You know, what is it that maybe has caused the courts to change? Um, it's simply witnessing. In this, I know this sounds superficial, but I think it's true. I think it's really just simply judges. Judges are humans who do the things with their cell phones and their computers that very often the rest of us do, and it's their own witnessing of the changing way that we create and work with copyrighted material. And it's their own witnessing of the implications of having a law that's either unduly rigid, or maybe you could even say from another perspective, unduly open and flexible. But they're becoming aware of the implications. I think that they're also becoming aware that if certain things are allowed, even large-scale activities like Hati Trust, if they are within confined circumstances with the technological controls, or even very specific activities. One of my favorite cases for learning lessons about modern fair use is the case about the rock and roll posters that are that are used in the book about the Grateful Dead. And while it's not the large-scale use of Hati Trust, it's a case that indicates a major change in the way the courts are willing to look at fair use and the four factors. Because I think they're also seeing that disaster doesn't occur if certain things are allowed to be fair use. And in fact, some good things may occur. In the rock and roll posters case, the good thing that occurs is somebody reading about the role of music and its cultural phenomenon, that they are able to have those visual images to better understand the subject. In the case of Hati Trust, the ability to have 10 million full-text digitized books has good effects for searchability, for finding books, for purchasing the books if you find something that's especially useful to you, and also the implications for people who are visually impaired and need the benefit of the technology. That not only can good things happen from the exercise of fair use, but disastrous, terrible things don't happen if those activities are allowed. And I think that has changed the outlook of the courts in their decisions. And then you asked more generally about the couple of important cases that are pending right now. This is also an exciting moment because the two cases you mentioned, Hati Trust and Georgia State involving the pieces of books for electronic reserves. And then there's a third case we could put in the mix, and that is the Google Books case about the digitizing and the building of that database. All three of those cases have a lot in common. They're about the large-scale digitization of text-based materials, but done so under very much controlled policy, technological circumstances. And then the question of, is this infringement or is this fair use? So each of those cases coming through the courts is going to tell us a lot about the digitization programs that we may have in general. And so they're very, very important cases, I'm sure, in many ways. Well, we have very strong favorable rulings in the Hati Trust. The Google Books case, favorable ruling from the district court, but it's up on appeal. Georgia State, favorable ruling from the district court, but it too is up on appeal. So we have a lot more ahead of us, and it wouldn't surprise me if one of those cases goes to the U.S. Supreme Court as well, because they have a lot in common. And I think the court may see that there's something important here that they should join in on. So those are some quick thoughts.
Thank you. See if any of my colleagues want to follow up with you.
Well, one thing I would just add to what you said, Kenny, particularly about the Georgia State, or I'm sorry, about the HathiTrust case and the Google Books case, is that copyright litigation takes a long time. And in some cases, by the time the judge was really sitting and looking at the Google Books case, for example, snippets and the use of those materials as part of a Google search had become commonplace and was somewhat the norm. And so I think that the comfort with technology, as you say, is a part of what has made judges more likely to find fair use. And hopefully that will continue. I understand the uncertainty around what technology implications have. There were a lot of cases around copiers when copiers came about. So as we adjust to new technologies, fair use and its interpretation expands and shifts as well. It's the benefit of fair use, that gray area and weighing those four factors that drives us a little nuts on the one hand, but proves to be our saving grace, quite frankly, often on the other hand.
Mm-hmm. Mm-hmm. I think that's right. It took from the time of filing the case, the Google Books case, to getting this latest substantive decision from just the first court, the district court. 7.5 years between filing and getting that decision. I don't know if it was the plan of the parties or not, but I suspect that the delay in getting a decision contributed to the positive result for Google, because it allowed time for the court to just learn and learn and learn about this project, about the implications, to think it through. And I bet Judge Chin, who decided that case, probably had a good sense of where he wanted to go with this decision, maybe 4 or 5 years into it. That might have been very different from what he would have said if he had to rule on it in the first year. So yeah, the passage of time is actually helping here.
Kenny, I'm just noticing a couple of. Oh, Ann, did you want to?
Yeah, and so when I was looking at the forums and looking at the questions people submitted ahead of time, one of the things people asked about a lot was, how can I reach a conclusion that I can employ fair use if I work for a for-profit institution of some sort? And that's often a sticking point for people. Well, can I use fair use if I work for a place that makes money? And one of the things I particularly noticed anew as you were talking about the copyright cases was that several of them have the strong policy impetus, but they're also commercial entities. Mm-hmm. And I wondered if you had any. I'm sure you've had some thoughts about that yourself, too.
Right. Well, absolutely. I saw that question in the list as well, and it jumped out at me. It's a very important question, and to put it simply, just to get to the chase, fair use can apply to commercial activity. Make no mistake about it. Just because your activity is commercial does not preclude the exercise of fair use. Now, on the other hand, the fair use that a commercial enterprise may enjoy might be less than the fair use that a nonprofit entity would enjoy. I remember being in conversation more than 10 years ago with somebody who was an official at a big for-profit educational organization, and it really doesn't matter which one, because the conversation would have been pretty much the same. And back then, he was saying that we regard fair use as having no application in our work. That was really more of a policy position, a convenience position for him to get his job done, rather than an accurate statement of the law. So I think what the University of North Carolina may be able to do as a matter of fair use might be very different from what commercial, private, uh, for-profit educational institution can do. But does fair use still exist? Yes. Google, you mentioned Google. The other case about the rock and roll posters, the defendant exercising fair use was a for-profit commercial publisher, and they.
Yeah, the policy impetus behind fair use doesn't go away completely when you start to make money. Yeah.
That's right. That's right. And courts have been saying this for years. We had some cases in the 90s involving the use of excerpts and quotations in a biography. Say the biography of J.D. Salinger was one of those that was litigated, and the court made really clear that even though this is a commercial product, it doesn't mean that there is no fair use. There still can be fair use. It just might be different, but it's still there.
So, Kenny, I was hoping to follow up with a couple of questions that have been typed in while we've been talking. Both of the two I picked out are focused on asking you to prognosticate a bit about the future of fair use.
The future of fair use?
The future of fair use. One specifically asks whether we have anything to fear or to hope for around fair use or in copyright in general from activity in Congress and from the Copyright Office talking about a new copyright law in the United States. And then one asks whether there's a risk that international pressure and the treaties that we've entered into over the last 20-some years will have the effect of eroding fair use in the United States.
Great question. Fair use is such a fundamental core aspect of American copyright law because it not only does it provide for that fluidity, that flexibility that's important for a good copyright law, but it also helps absorb some of the issues about free speech. So that we can use elements of some work to criticize, to comment on it, and that's an exercise of our free speech rights. And so fair use is critical for that purpose as well. So I have heard many very senior government, U.S. government officials comment on the importance of fair use. And express great support for its survival in whatever form. So I'm not living with a lot of concern that any time that we can forecast we will see fair use disappear, or even that Congress will change it in any significant way. Most of the development of fair use is in the courts anyway, and so I think we'll see court decisions ebb and flow as we argue these issues and as our needs and circumstances change as cases are brought before courts. So I think that's where most of the activity will be. There is some criticism in the international setting about the appropriateness of fair use in our multinational treaties. You've probably in this course talked about the Berne Convention, Berne, B-E-R-N-E, the Berne Convention. And the Berne Convention doesn't specifically provide for much about exceptions like fair use, but it adopts this very, very fluid, in fact almost oblique concept called the three-step test, that each exception that a country adopts must conform to this three-step test. Well, we really don't know very much about what that three-step test means in any practical sense. So we're always kind of guessing our way through it. There are some countries that have criticized the U.S. fair use as being a violation of that three-step test. On the other hand, we have a handful of countries around the world that are borrowing our language of fair use and are adopting it in one form or another as part of their copyright law. So we're seeing it show up in recent amendments of copyright laws in various, very diverse countries around the world. So I don't live in with great concern that it will go away. I think we need to watch for sort of backhand attacks on it. One of the other questions somebody raised before the session was about the role of licenses, and can licenses undercut fair use? And the short answer is yes, they can, so be careful what you sign. And so we have to be watchful of that. We also have to be watchful about these arguments that specific exceptions, like the exception for libraries, the exception for education, can be the exclusive definition of uses of works by libraries, by educators. That's just not true. Fair use continues to survive, and we have to hope that no court or that Congress doesn't buy into that argument at any time in the future. So I watch for those kinds of attacks.
Yeah, and we saw the courts reject that argument explicitly in the HathiTrust case, where it was argued that Section 108 undermined libraries' abilities to rely on fair use.
Absolutely.
The court rejected it there, but I think you're right that we may well see that come up again and again.
Yeah, or that any new amendment in Congress may include a provision that says, here is our new Section 108, and this is the 100% exclusive domain of what libraries can do. We need to be watchful of that.
Right, right. Anybody want to pose a question here, or I have a list.
Yeah.
Well, there were a lot of good questions, and we already touched on two of my favorites from the list. One about licenses, and one about treaties, and there's a lot more we can say about treaties. Let me just add this, and then Lisa, Kevin, and I'll defer to you with the next question. Just in general, I've been teaching copyright law for a lot of years, and early in my teaching of copyright law, I realized I couldn't make sense of U.S. copyright law without putting it in the context of the international treaties. Because if you ask the question, let's deal with something really, really tangible. Why do we have copyright law that lasts for the life of the author plus 50 and now 70 years? Why do we have that? Well, we can make all sorts of policy arguments that it's a good idea this way, it's a bad idea that way. We can debate that endlessly. There's plenty of room to debate it. But the real answer is because we have to. Because our multinational treaties, like the Berne Convention, say that if we're going to be a part of the international club, you have to conform your law to certain rules. So Congress, every member of Congress might think it would be a great idea to roll the duration of copyright back to, say, life of the author plus 20 years instead of 50 or 70. That might be a great idea. Congress might be completely convinced. But to do so means we would have to abrogate our ratification of several multinational treaties, including the World Trade Organization treaty. And so these multinational treaties have the effect of locking countries in to certain structures of the law. Not only we, every country in the world is losing an element of its autonomous decision-making by deferring many of these questions to the treaty context. And I think that's a real problem in the development of the law and the chance to experiment with new ways of sketching out copyright law.
One additional thing, Kenny, that I think often confuses people that maybe you can help clarify is the application of copyright law when you're using works that were created and copyrighted in another country and not your own country.
Right.
So maybe if you could clarify that a little bit, I think that would be helpful as well.
Yeah, this is another consequence. Most of this, probably most of us would say, is a good thing, but there are some problems with it. This is another consequence of our multinational treaties. The multinational treaties fundamentally do two things. One we've already said. The one thing they do is they set substantive requirements for the shape of each country's law. That you will have copyright, it will be like this, and it will last this long, and so on and so on. So it does that. The second thing that they do is they provide for national treatment. National treatment is that you meaning a country like the United States, or pick any of the other 190 or so countries that are participants in different treaties, that your country will provide copyright protection for the works that come from other countries on at least the same terms that you protect your domestic works. So that means that then that I'm here in the United States and I go to my library and there's a huge wall of books in my library and they're from different countries, originally published in different countries. And let's assume they're all from countries that are part of the Berne Convention and part of the WTO, which is probably a safe assumption because that's most countries of the world. That in general, there are some variations, but in general, I would treat those works the same as I would the domestic work. So if U.S. law says you get automatic protection for life plus 70, that work from the other countries probably going to get the same bundle of rules. If I can apply fair use to my U.S. domestic book, I can apply fair use to that book that came from France or Japan or Brazil or any of the other countries. So we in general apply the same rules. Then the variations become very technical, but can be very important.
So I want to follow up with a question I just saw pop up. I don't know if the history of these negotiations is part of your expertise, but I expect that it is. One of our participants asks, why did the WIPO, why did they pick such a long term? Why did they pick life plus 50 as what is really the minimum now?
Yeah, it's great. And in fact, if you go to the Berne Convention, there are 4 or 5, maybe 6 different rules, because there's a basic rule of life plus 50, as Kevin, as you say, it's a minimum. And so the U.S. and many other countries of the world have gone to life plus 70. And then there are shorter terms. There's 50 years for cinematographic works, movies. There's a 25, I think now 50-year term for photographs. Sound recordings, I think, are still at 50 from date of release. And so you have these different calculations for different purposes. And these are all minimums. And then the European Union has adopted some directives that establish higher rules. The United States enacted statutes that generally apply life plus 70 to all of those different works that I just listed, and then a bundle of other rules for works made for hire. So the U.S., the European Union, and some other countries of the world have gone to higher terms. So back to your question, why such a long term? It is interesting. History of life plus, having life plus a period of years, is really rooted in French law. And it's really rooted in the French Enlightenment. You can find the first of these statutes that provide copyright for life plus, I think the first one was 5 years and then 10 years. That these were first adopted in French law more than 200 years ago. That they're part of a concept that artistic or literary work is an extension of the person, and that the person should not live to see that work enter the public domain, because that's an extension of the person and is a outward creative expression from that person. And then the plus becomes real practical. You know, should it provide some benefit for the heirs? Should it provide some benefit for the ongoing reputational interests of the person? Or you think in practical terms today, if I write a novel and I sell the movie rights to a film studio, well, if my copyright expires when I die, if I died tomorrow, that sale is worthless because now it's gone into the public domain and the right derivative works. So just to be practical, there's some pressure to have added years and added years. So it's a little bit practical, and it's a little bit ethereal and philosophical. And then it really was locked in with the Berne Convention and the early versions of the Berne Convention.
Well, I'd like to follow up one more aspect of international copyright before we turn away from that, if I may.
Sure. Please.
Another thing that the Berne Convention and the other international treaties does is require that countries permit the enjoyment of the rights under copyright without formalities, without any legal obstacles. Right. And for the U.S., that was a dramatic change. We had to do away with some of our rules about registration, about notice, and about renewal.
Yep.
And a lot of people, and I'm one of them, have criticized that the effect that that has had on American copyright law. I mean, we've created this immense orphan works problem because of works that probably would not have been renewed under the older regime where a copyright, if it wasn't renewed after 28 years, was lost. So my question is, there are a lot of proposals for trying to fix that problem. I just want to try one out on you and see what you think. Suppose the United States, in order to address this concern that copyright lasts for too long over things that nobody is exploiting, suppose that the U.S. decided to reimpose a renewal right, or a renewal obligation, excuse me, only on U.S. citizens. Do you think we could do that?
It's a great question. If under the Berne Convention, the answer is yes, we could do that, because the Berne Convention, you know, you and I probably in what we just said probably left the impression that the Berne Convention makes requirements about our own protection of our own works. And I've probably said things like that many times, but a dark little secret of the Berne Convention is it really doesn't do that. Yeah. It's really only about foreign works. But so therefore, technically under the Berne Convention, Kevin, your proposal would survive a challenge under the Berne Convention, because you don't have to provide protection for your own works. You just have to provide at least the same protection for foreign works. But then you add the more recent treaty. When you add, starting in 1976, the World Trade Organization and TRIPS, that goes further in requiring protection. And then you add the bilateral trade agreements that we've entered into. Now we're committing to having certain protections under certain rules to the various countries that we've entered into in these regional or bilateral agreements. So those more recent trade agreements have changed the rules. I doubt that your proposal could survive a challenge under those treaties. That would be the more recent challenge. Berne Convention, it would survive, but not under the more recent agreements, I believe.
Interesting. Thank you.
What I thought you were going to say? You want to know what proposal? Suppose the U.S. in 1998, when it added 20 years to the term from life plus 50 to life plus 70. Suppose that Congress had said, we're going to change the rule by adding 20 years, but you have to register to get your 20 years. You have to show up and claim it. That, I think, would be completely permissible under all of those agreements that I mentioned. Perfectly permissible.
And hasn't the Registrar of Copyrights recently suggested something similar to that?
They have, and that was a bit of a change of tone. Yeah, they not but a couple of years ago there was a great deal of concern about any such idea because they were just feeling the stress at the Copyright Office of being understaffed, underfunded. They were just not in a good position to take on that massive responsibility. And I think they've come to the position that if there's a good idea out there that it might pass Congress and might be acceptable under our treaties, let's see if we can advance it and see if we can make some real change here. And that's a good thing.
So one of the questions in the Google Hangout that I think is one that comes up for librarians quite frequently is the impact of licensing of digital content on the notion of the first sale doctrine. And the first sale doctrine's inability, shall we say, to easily translate into a digital world. Thoughts on that?
I do. I think this is a hugely important issue, and the courts that have touched it are realizing how much they are burdened by really the plain language of the statutes. If you buy a book and you want to give it away to your friend, you're free to do that. And but if you buy a digital book and you give away that ebook to a friend, technologically it's the making of a copy. And because at least momentarily you still have your copy on your machine. So it isn't giving away the file, it's reproducing the file. And this is the problem that honestly, when Congress enacted these statutes, probably wasn't thinking very much about. Yeah. And so the courts that have addressed it have just come to the conclusion that this language of the statute just doesn't give the courts very much choice. So I think this is an issue that's going to be pushed to Congress, and we really need to find a way to resolve it. I certainly understand the arguments, the concerns about the publishers of all different forms of media, movie, music, books, you name it. They have concerns, and I think we have to appreciate those and work with them on these concerns. The concerns about the proliferation of copies and so on. Where's the control? So I think we need to find a legal, technological resolution that allows for the transfer of these files to other people under terms that realistically results in just that one copy being disseminated. And we know that in the court cases, different companies like Redigi have attempted to develop a solution. And I think they should be applauded for that, but they knew that they were just running headlong into a legal mess. So it's gonna be pushed back to Congress, and we should all get involved.
So write your congressman.
Write your congressman, congresswoman, your member of Congress. Yeah.
Kenny, I have a completely different question, and one actually that I don't know the answer to at all, and that is, how did you get into copyright? What?
Oh my goodness! Oh my goodness! You really do want this biography. Thank you. I was well, let me tell you right now. Today, I'm a lawyer in Los Angeles, and I'm working with copyright. I'm working with copyright for libraries, for universities. I'm working with a scholarly publisher and redoing their agreements and their terms in which they're doing work. And so I'm supporting. I'm continue. My heart is in the same place. I continue to support the world of scholarship and education and research that we are all part of. I'm just doing it in a different way. I'm working from this point. But I'll tell you what life has done, circumstances and so on, have taken us in this full circle. And I'm back in LA working with some people I worked with more than 30 years ago in a building that's just a block away from a building where I was working way back then as a lawyer. And I was doing some work in this, had the opportunity to be involved in some interesting copyright matters, and always found them fascinating. What I found fascinating was not just the law, but the fact that you could work with the law and you could be working with literature and music and art and all of these good things. So what better law is it than that you can work in professional legal matters and deal with these great creations. And so I was very excited about copyright. But I knew I wanted to pursue this academic direction and investigated some alternatives. And a good friend was a faculty member at UCLA in the Library and Information Science program. And he invited me to come on up and meet with people. And what I discovered was how much they were interested in copyright. And that was news to me. Now imagine, that was 1984 when I'm having these conversations. That was a long time ago. And discovering that they were very interested in many of the same things that I was interested in. And that drew me in. And so I enrolled in the library program. I did a PhD in the UCLA library program. My PhD dissertation was on fair use policies at research universities. That got me hooked on fair use. It got me hooked on universities. Then I went out on the job market and discovered in 1990, with fresh PhD in hand, that nobody understood it. Nobody had any clue. And I would interview. I mean, literally, you do your little canned speech when you show up for an interview, and they say, "Well, tell us about your dissertation." And I would say, I've analyzed university policies on fair use and their implications for the work that we do as faculty, as members of this great university community. And I would get this dead stare, and people would say, "Copyright and us?
Yeah.
Are there any issues there?" And just a total blank. And the place where I landed my first appointment was in a business school, teaching business law in Northern California at San Jose. Everybody out there from San Jose State, yay. And because I interviewed, and that's the one place where everybody around the table said, "I get it, and here's how it relates to what we're doing." That's the one place. And then 4 years later, Indiana University formed the first policy office addressing these issues. And they found me because I was publishing, and I had an early book in this area that was founded in my dissertation. And they recruited me, and I went to Indiana, and I was there for 14 years. And then I went to Columbia, and I was there for 6 years. And now I've come full circle, and I'm back home. I'm back home in Los Angeles, and I'm talking with you, my wonderful colleagues.
I just have to say, though, Kenny, I just have to say that the fact that so many universities get it now,
Yeah.
no small part due to the influence that you've had. So most of us didn't have quite that struggle to get a job. Owe you some thanks. We really do.
Well, my pleasure. I'm glad to have you all as colleagues.
It was interesting that you talked about, and I've said this many times, that one of the things I love about my job is that I get to apply what is an interesting, if sometimes maddening, portion of the law to such really fascinating content and problems and projects. Yeah. So with that in mind, let me go back to one of the questions from the discussion forum that you and I both sort of pulled out before we started. And that's the person who asked about the copyright situation when the original work is in the public domain, but there are derivative works that are still protected by copyright. The person who asked the question specifically referred to The Wizard of Oz, where L. Frank Baum's book is presumably, I don't know this, but I'll take her word for it, in the public domain, but the movie is not.
Right.
Or at least arguably the movie is not. It also made me think of the recent Sherlock Holmes case,
Yes.
where
Yes.
some of the stories are in the public domain and some are not. So I wondered if you'd comment on that situation.
Yeah, I'd be happy to. Basic rule, rules that we all know, and I'm sure you covered thoroughly. Copyright exists, copyright applies, copyright lasts for a long period of years, and so eventually works enter the public domain. And by the way, please avoid, and I'm saying this to everybody out there in MOOC land, when you talk about this, please don't talk about works falling into the public domain. They don't fall. It's a happy place where they
ascend.
They ascend. They grow wings. They enter the public domain. You know, you can say ascend, you can say fall, but at least enter is a little bit more neutral and less biblical, I think. And so they enter the public domain. And so, speaking of biblical, you know, if I have original Aramaic text and Greek text from thousands of years ago, I think it's safe to say those enter the public domain, although I can think of reasons why they haven't. But a modern translation, and somebody else asked a question just minutes ago about translations. A modern translation of a public domain work is a new copyright protected work. A movie, Wizard of Oz, let's pretend like the original book is in the public domain and has been and was when the movie was made. So, but the new movie has new elements and is a new copyright protected derivative work. In whether it's the translation or the movie, the new copyright protects the new expressive creative elements. In the case of a movie made from a book that's mostly words and some pictures, there's a lot of new creativity. There's new dialogue, there's new set direction, there's new art direction, there's new makeup, there are new characters. In the case of a translation, it's new words, it's interpretation, it's decision-making, choices the translator makes. It's not the machine-run translation. And so therefore, there's plenty there that is new and is expressive. So there's new protection for that. So jumping back to the person's original question about Wizard of Oz, if today I am going to make some production or some project about the Wizard of Oz, if I can go all the way back to the original and use elements from the public domain original, or the recent case about Sherlock Holmes, confirm that the early stories are in the public domain. If I can dip back into those and use only those public domain elements, I'm fine. If I dip into the movie from 1939, I'm not so fine, because that has plenty of 1939 new copyright protected elements. So we need to always know what that cutoff is. And you know, it reminds me, one of the other questions I saw in skimming your questions ahead of time was somebody said, well, how do we know whether a work is a work made for hire or not? And that makes a huge difference in the expiration of the copyright. And sadly, the answer is we don't. and sadly, the answer to that question is often in the private agreements and files that belong to an author from long ago or a publisher from long ago, and you're lucky if they kept those files. They may have dropped them in the shredder decades and decades ago. We just often don't know. And this is one of the perplexing things about copyright. You're trying to figure out when the copyright expired, and you just sometimes can't get the facts that you need to make that determination.
I think that's a really important point, and I just want to reiterate it, that so often we know what the rules are and can't determine the facts that are necessary to make a public domain determination. By the way, it's also a reason why the work that we do in libraries and archives can be so important, because we are often the place that's preserving that material.
Right.
And I'm sure many, you know, certainly, because you and I are both on the advisory board for the copyright management project in the Hathi Trust, that that's a project to try and determine some of the facts behind public domain decisions. And sometimes they're able to decide that a work is in the public domain and make it available through the Hathi Trust to the public. But even when they don't determine if they either can't decide or if they decide it's still protected by copyright, they're learning facts. They're digging up facts that are immensely valuable in a few years for continuing to make those determinations.
Yeah, just a simple example. Frequently, I'll get a question from somebody who's working on a project, and they have a book from, say, 1940, and the question is this book in the public domain? And usually my first answer is, how badly do you need to know? Because
absolutely,
this may be a research project, and you really need that book, or can another one work that has easier facts? And then the other point that I get to early in the conversation with that person making the request is, we can research this, but there's a pretty good chance that we won't definitively find the facts that we need. And therefore, the answer that you get might be it is most likely that, and without a definitive yes or no. And are you ready to cope with that? Are you ready to make a decision based upon likelihoods rather than certainty? And for those of us trained in the law, that's what we do. Very little in the law. Very little in the law has answers. Probably everybody out there watching the program right now is mortified and disappointed to hear me say this. But if you've had a law background, whether it's an issue of a car accident or estate planning or national security, there are very few answers. The law tends to point directions, and then we are asked to make judgment calls in that context. And that's what we have, too, in copyright to a great extent.
I just saw an email where a lawyer referred to one of her law professors who said that that's a situation where you need to, quote, make a noise like a lawyer, by which you want to say, it depends, I don't know, how badly do you need to know?
Yeah, it depends. It depends. We live by that. Yeah. Let me tell you a funny story. When one of the first things when you go to law school, usually in the first semester, you learn this thing in property class called the rule against perpetuities.
It makes all of us cringe. Yes.
Yeah, that's right. That's right. Everybody should now go to their library and check out the movie Body Heat and watch it. It's a great movie, and at the core of it is bewilderment about the rule against perpetuities. And so this, you learn this, and you also learn, oh, don't worry about it. It hasn't been important since about the year 1400 or something. And in my law practice experience, decades ago, I'm a brand new lawyer. In the first 6 months, I had 2 complicated issues involving the rule against perpetuities. Then I go on this copyright expedition for all these years, and one of the baffling, bewildering things about copyright is termination of transfers. And you learn, oh, this is the most convoluted aspect of the law. And then I'm back here in setting up my office, and I'm working here, and within the first couple of months I have 2 two complicated issues involving termination of transfers. So, these things are out there, and the law is fun, and the law is baffling, and it's always good for an adventure. Don't look for answers, though.
Just likelihoods.
Likelihoods. Be ready to make judgment calls. Well, and that takes me back to. Let me throw this in. I hope we aren't running out of time. I know you got me on this binge now, telling stories here. So when I was at Columbia and at Indiana, I would frequently get an email from somebody saying, "Hi, I am the research assistant for somebody, faculty member, and I was told I should talk with you about the copyright implications of this book or this project." And I'll say, "Great, I'm happy to meet with you, happy to help, but I need your professor there. The professor whose project it is needs to come to the meeting." And they don't expect that. They expect, let me just send the research assistant, and this guy who sits in an office will dispense answers, and that will end all of our problems. And no, I make the point that you need to be there, because there are going to be decisions that you have to make. And they may be decisions about judgment calls, about what isn't in the public domain. They may be decisions about how to work with your publisher. They may be decisions about choosing to leave something out that you felt was important and needed to be in the book because they're copyright problems. These are the judgment calls that are practical rather than legal, but they're all tied in with the law. Judgment calls that we often need to make. So as you get into this copyright world, you have to be ready to not look up answers, but help people make reasoned decisions.
I will say, Kenny, I have the same approach, because often one of the things that you quickly get into is kind of who has rights and what, or where something came from, and seldom is it the admin assistant or the research assistant, and often the faculty member themselves who have to answer that. The one plausible excuse that I did accept on one occasion was that the faculty member was in surgery.
Oh, well.
Couldn't get out of surgery, and I thought that actually him continuing with the surgery was probably more important than the copyright questions on the table.
That is full attention. Yeah.
What I wanted to know was the faculty member the surgeon or the patient?
Yes, the faculty member was the surgeon. Yes.
Oh, I misunderstood. I had visions of a faculty member on serious painkillers.
No.
And that could help.
No, he was performing the surgery.
Yeah, okay. Hey, we better help out our friends out here. You have more questions you want to be sure to cover? Oh, here's a good one. I see one that popped up. If an author assigned all rights to a publisher, who is responsible or liable for copyright compliance? Meaning if there, and they say, or violation, meaning if there are violations in the book, for example, and you assign the copyright over to the publisher, which, number one, please avoid doing that, but you did it. And who's liable? That's a great question. Those are two separate things. But fundamentally, the publisher is the one who is making the reproductions. Let's say there's a photograph it turns out to not be fair use and is an infringement. The publisher is making the distributions. The publisher is making the reproductions and the distributions. It's the publisher that's doing the infringing activity. So fundamentally, they're responsible. You might be responsible for contributory infringement, etc. But that's only half an answer. The other half of the answer is read your contract. Because the contract with a book publisher or journal publisher typically says you, the author, agree to be liable and to indemnify the publisher against any losses. So, which means the publisher is still liable to the outside world. But if they have to pay $1 million to somebody, they're entitled under that contract to come back after you to seek recovery of those funds, whether you have that much money or not. They can lean on you until they get repaid. So be careful, be careful, be careful what you sign, and still don't worry about the who's liable. Just worry about making good decisions.
But I think that's so important, and the paragraphs in publication contracts that say warranties and indemnifications tend to make people's eyes glaze over, and they think that's something I can skip. It's really very, very important. And I've seen some, in my opinion, unconscionable indemnifications in book publishing contracts where an author, for example, was asked to agree to take an insurance policy in the state where the press was resident in order to guarantee his ability to indemnify the press if there were any claims. That's just, to me, an absurd requirement to make of an academic author.
Yeah, it's time to find another publisher.
Yeah.
Which is not always so easy when you're publishing something in a very specific field that the publisher specializes in.
Right. Right. Good. Other questions? Which ones do you want to pick up?
Well, I think there have been a number of questions. There were some on the forum as well around images on Google and the use of images. It's so easy to find images using a Google search. And for whatever reason, there tends to be some confusion then around kind of applying copyright to those images. And there's also sometimes confusion around thumbnails and whether or not thumbnails are always a fair use or sometimes a fair use. So maybe, Kenny, if you want to talk a little bit about, I mean, there's been some cases around thumbnails, and then also just that general perception that if I find it on Google, I can use it because, after all, it came from Google.
Right. And did it really come from Google? Just because you used Google as your search tool doesn't mean it came from Google at all, because of course what Google does is lead you to other websites, and so it came from there. And the answer to the question, as I best understood it, is no. You just can't assume anything. So you found something by whatever means, wherever it might be, out there on the web. You have to just make a reasonable investigation and make a decision accordingly. If you found on somebody's website that perfect picture of a mountain scene that is perfect for your PowerPoint presentation and demonstrating whatever point you're making, that's great. You know, it may be fair use, especially if it's a limited circumstance of you're going to put it in your slide. It's going to go nowhere except you and this one talk that you're going to give. Maybe that's fair use. Ethically, give credit. Give credit where credit is due. Do that for ethical purposes. Do that for scholarly academic honesty purposes, and do that for your own self-benefit. Very often I have people come to me and say, well, I used this picture last year and now I want to reprint it in a book. I need to go find how to get permission. And I'll say, yeah, fine. Where'd you get the picture? Well, yeah. I don't know. I forgot to keep track of it.
That happens a lot.
Yeah. Add a footnote to your PowerPoint slides, and you can do that any number of ways. Give a little credit box on the slide, put a note in the last slide. Do something. Give credit where credit is due for all those important reasons. And just because you found it out there doesn't mean it's in the clear. And it may imply that it's okay to use it within limited circumstances if it's freely out there. But then again, it may be a brilliant, expensive photograph by a brilliant photographer who's trying to earn a living, and the person who put it on the website didn't have authority to put it there. So you just don't know. Your better bet is to go into Flickr or one of these multitudes of other sources where you can get works that are there with a Creative Commons license, or there because they're placed in the public domain by the rights holders. Go to those kind of sources and use that kind of work. And be flexible, be ready to choose different works, because you can clear the rights instantly, much more easily, and move on with your project and get the copyright thing off your desk as quickly as possible.
Kenny, I love your point about why you give credit, and I just want to take a minute to elaborate. In the rest of this week, I'm giving 8 or 9 different presentations to graduate students who are entering as master's and doctoral students at Duke. And one of the things I'm often asked to talk about is plagiarism.
Yeah.
And one of my favorite approaches to the issue of plagiarism comes from another colleague, Deborah Gerhardt, who teaches in the law school at UNC Chapel Hill, where Ann is. And Deborah wrote an article in which she talks about the issue of plagiarism and acknowledgement as an issue of voice, of acknowledging the voices of others and distinguishing and sort of defining our own voice. And I love that, and it often, I think, speaks to students in a way that just saying, no, 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 you're not supposed to do that, doesn't.
Yeah.
The reason we give credit is to acknowledge someone else's voice, but also to make clear what's me.
I love it. I love it. I think that's great. I'm glad you brought it up, and I'll add that to my list. and really related to that is, it's easy to complain about, gee, do I have to give credit? Why can't I just use stuff? Similarly, along the lines of what Kevin, what you just said, sometimes not being able to just use something means you actually have to go and create your own. Yeah. And so it is as awkward as it is to try to convince somebody of this. Sometimes not being allowed to just take something means that we're adding to the creative resources, because now you are pushed to go and do something original and get that job done. I'll also frequently say to other instructors that really want to use this chapter out of a book or whatever, and their problems that have come up, and I'll say, well, it's a pretty straightforward chapter summarizing the field. You've been teaching this for years. Why don't you just write your own? You're the expert, and if you write your own, it's yours. You can do what you want with it. And once in a while, I actually get somebody who says that's a good idea. Not always, though.
Well, I'll follow up with a question. Lisa asked you about images. So this is a slightly different approach or question about images. It's one that I get a lot. Somebody in the discussion forums asked about older photographs, and she specifically said, say the photograph is from 1910. And then I mentioned the date for obvious reasons. Do I need to get permission to use that photograph from the descendants of the photographer, or do I need to get permission from the descendants of the subject? And I think this issue of permission from the subjects of photographs is something that comes up a lot.
Yeah, it's really good. Under American law, copyright vests in the making of the image. And did you say 1910 because that rather assures us that it's in the public domain?
Yes.
Although don't be too quick.
You're going to make a voice like a lawyer, aren't you?
I am. I'm just to ruin the day for everybody out there listening. Think about the professional photographer sitting in a studio, working for a photo studio, taking pictures for people who come in and pay money to have these photographs. That starts to sound like a work-for-hire situation. Photographer working for the company that is the photo studio. Well, an unpublished, now you dig through the box of old family photos and you pull this one out from 1910. Well, an unpublished work for hire has copyright protection for, what is it, 120 years? So, which means that clocks us all the way back to 1894. So, which means if we really start counting these rules and applying them, virtually the whole history of publicly available professional photography is still under protection by copyright. It's outrageous. So 1910 doesn't even solve all of our dilemmas. But if the work is protected, not protected, whatever year it's from, if it's protected, the photographer presumably, or the employer of the photographer, presumably owns the copyright in the photograph. The people in the photograph may have what's called right of publicity. That's a separate right established by state law that gives them the right to prevent the use of their images in usually commercial uses. So if you're reprinting that photograph, as I did in this handy book, there's a photograph in there of it's an old family photograph, and it raises exactly these same dilemmas. And my punchline is, I hope my relatives don't sue me, because there are possible rights that the individuals have, probably not in this instance. There are possible rights that a photographer has, and we don't have the documentation to confirm, is this work for hire, not work for hire. So these are dilemmas. And what it means is, back to that previous point, notice you didn't get an answer. Everybody out there is wishing, so darn it, where's the answer? You didn't get an answer. You're now called upon, if you're the author, you're the publisher, you're building that website, and you want to use that picture, you're called upon to make a judgment call. You're called upon to make a reasoned, reasonable, informed, good faith decision. And that's why we need to all be involved in this. And we need to have the counsel of people like all of our instructors at the institutions to help each of us through this process in making more informed decisions.
And since you held up the book, I'll take the opportunity to thank you for making it possible for our participants to read 3 chapters from the book.
My pleasure. I hope you enjoy it, and please send any comments. Hey, I saw a couple of really good questions scroll by recently. Can we dive in?
Go ahead.
Yes.
Yeah, one of them says, I see a lot of guidelines about using materials like 30 seconds of a song or video, or 10% of a work. Until the Georgia State case, any semblance of quantified rules like that never showed up in the law. They've all been, all of those things that you've read over the years about 10% or 30 seconds or whatever. A lot of that is just somebody's interpretation. Those guidelines that were mentioned in the question, those are just somebody's interpretation. They are absolutely, positively not the law. So you can choose to follow them or not choose to follow them. And I think others out there have written extensively about the weakness and the problems of those guidelines. And so be very, very careful about that. And there's a lot more you can read about that elsewhere. So I alluded to the Georgia State case. The Georgia State case, at least the district court decision, did reference a 10% one chapter kind of rule, and I think I'm overstating it by saying rule. It's been read by a lot of people to be a rule, and I don't believe it's a rule. I think that what it was in the Georgia State case was a tipping point where the court was basically saying to itself, if we see that the use is more than this 10% or one chapter, then we will look further for evidence of actual harm to the licensing market. I think it was just a point for the court, and hence for each of us trying to follow the rules of the court, the point for the court to investigate further to see if this is still within fair use by other evidence. So, thoughts about that from the others?
Yeah, I was going to say, I think that's a really important point. And I would also point out that no matter how we interpret that 10%, it was a statement about what the court thought was appropriate in that context. That is, in the context Correct. Of excerpts that were being used in a closed system for course readings. So what really bothers me is when I sometimes hear the Georgia State Court said that fair use is limited to 10%.
Right.
It's in a very specific context for a very specific purpose. It says nothing about how much video you can use in your mashup or how much music you can use as background for your PowerPoint presentation. It says nothing about those situations.
That's right. And yet, if this case, let's assume it's the end of the line. We know it's not because it's up on appeal. But if this case were the end of the line, you know, because there's so few cases for us to turn to for these questions, if you had a question, if I had a question about the use of video in some academic multimedia project, you know, we'd still look at the Georgia State case to try to draw some general lessons, even though the case itself doesn't decide anything about video, for example. But we'd look at the more general language and say, what does this suggest to us might be the right answer about fair use of video? It's the nature of the law. I saw another really good question, and it was about the use of a state government agency librarian. I bet there are a lot of people out there that work for state agencies. The University of North Carolina is a state agency, for example, and there are others out there who work for different kind of state government agencies. There are probably plenty of people out there who work for federal agencies in different capacities. For the most part, the copyright rules are the same. The U.S. government engages in fair use. They've had lawyers very actively addressing some important issues about fair use, their own activities. The U.S. government produces a lot of material. U.S. government works are in the public domain, but the U.S. government publishes a lot of material that comes from other sources. One of you in one of your early videos said something about a national park brochure, for example. I picked one up last week, and sure enough, the brochure itself is produced by the U.S. government, but a couple of the photographs came from professional photographers and has their own little separate copyright notice. So the brochure in general is public domain, but not 100% public domain. So we have to look very carefully at that. State government, all that stuff is protected by copyright. Then with the other advantage, though, that states have, and it came up in the Georgia State University case, is this thing called sovereign immunity, where under the U.S. Constitution, a state agency cannot be held liable in federal court for dollar damages, for money. And so an issue in the Georgia State case, could you sue the university for money if they're found to be infringing copyright? And the general rule is no. But you can sue the state agency for an injunction to get them to stop. So if you prevail in your arguments, you can get a court order saying that the state agency, the state university, needs to stop what it's doing. And really, the district court did that. It entered an order saying, we hereby order Georgia State University to exercise fair use only within the meaning of this decision we just handed down. Basically said, stop violating fair use, but then, by the way, you really didn't in the process except in those 5 instances that we found. So, not bad. We'll see what happens to that on appeal.
We have just a few minutes left. I'm going to ask Ann and Lisa if they have any other questions they want to pose to you.
Well, I think there's a question that's just come in that relates to your example that you just gave, Kenny, around PowerPoints and using music behind a PowerPoint presentation or video being prohibited because the copyright holder has exclusive synchronization rights. And as we know, music is always a copyright challenge. So maybe if you could kind of help clarify some of the rights in music and exactly what the synchronization rights do cover.
Yeah, that's really good. Synchronization rights are usually referred to as the right to take the music and incorporate it into what we might call a derivative work. So you're going to use it as the easiest one that we've all seen is that famous song is used as background music in a movie scene or a television scene. That's an exercise of a synchronization right. Now let me hasten to add that there's no such thing in the law. It's really an expression, synchronization right, and a synchronization license that's used in the movie, TV, music trade. And what it really is legally is it's saying, I want you're the copyright owner of this this great piece of music, and I want to take that sound of somebody singing I'm happy, I'm happy, I'm happy, and put it all into the background of a production I'm making. I am reproducing the work. I'm incorporating it into an overall visual audible scene, so it may be a derivative work. It may be, and then I'm going to show it in movie theaters. I'm going to make public performance. So the synchronization right is just a license to bundle those pieces together of the law to get your job done, to get your film production done. And so you do all that. So what you're saying is, if I want to now use a clip of that music into the PowerPoint slide presentation that I'm giving, what I'm really left with is I am reproducing that clip of music. I'm going to incorporate it into something else. Maybe that's a derivative work. And I'm going to click the button so that people in the audience can hear it. And that's maybe a public performance of the work. You have the same choice as you would if it were text, if it were anything else. You need to identify whether this work is protected, who the rights holders might be, determine whether it's fair use or within some other exception. If it's not, then you're off to get permission from whoever the rights holders may be for that particular work. The music industry is not well set up to provide easy permissions for that kind of thing. So if it's a brief clip used in an educational context, you got a darn good chance that this might be fair use. So you go back to your lessons about fair use, you apply all 4 factors, you keep notes, you use the checklist, you use any other tool you like, and you keep a record of what you've done, you put it in your permanent file, and in case anybody questions what you've done, you can explain that you made this reasoned, good faith decision, and that's going to help you.
So, Kenny, I have a wide open question, but of course you have not very long to answer it, so, which is maybe a good thing and a bad thing. What do you think will be the next issues of contention in copyright, issues of litigation, or of, at least posturing an argument?
Yes. Well, there'll be a lot. We're going to have litigation on 1,000 different issues in copyright for many years to come. And we're going to have 1,000 different issues that are going to be in front of congressional committees for years to come as Congress starts to explore these issues on a large scale. But what's the issue that I think is big issue that's lurking out there, that's of immediate importance to your viewers, people who are interested in education, libraries, research, scholarly publishing? What do I think is the big issue?
Yeah.
Ready? You ready?
I'm ready.
Work made for hire.
Oh.
I think that is ready to explode. And I'll tell you, I will tell you why. That as academics, we've all made the argument that this work that we're producing, a scholarly article, stick with the most familiar, is not work made for hire. And I've been part of that chorus. I think it's very important that those not be work made for hire, philosophically, pragmatically, a whole host of reasons, that they're not work made for hire. However, that's not the direction the law is going. If you look at these several cases about articles, about course materials, about all kinds of things that are that where a faculty member created them, and it was in connection with the advancement in your career and your duties at the university, the courts are generally ruling that a lot of that is work made for hire. And the couple of courts that have addressed those university policies that say it's not work made for hire have said that doesn't solve it, because under the law, a policy does not work that way. A policy alone cannot change the work made for hire outcome. So there's a serious lingering problem out there, and I think it's going to show up. For example, think about the university repositories that we're all establishing. So now here comes, say, a real lawsuit over something being in that repository, and it's a faculty member's research paper. Well, whose copyright is it anyway? If the publisher says it's mine and I'm going to sue you because you won't remove our material from your repository, well, part of the defense is going to be from the university, could easily be something like, well, let's see the agreement that transferred the copyright over to you. And if the agreement is signed by the professor who wrote the article, the answer from the university might be that's not good enough, because those are all works made for hire, and we own the copyright, and therefore the professor had no authority to transfer it over. And so we're going to see this cut in a number of different ways. So the earlier, and I've worked with many universities on this issue, the earlier that they address the work from the context of scholarly works, teaching materials, online education, especially online education, and the host of other materials that we're creating, having good policy, and I know I just said policy alone may not work, having good written agreements in place, good systems for monitoring that information and storing that information, and thinking about the issue not as me or you, not as it is or isn't work for hire, but how can we in a more nuanced way share the set of rights? Who gets to do what, and not think of it as it's all mine or all yours. How can we, by policy and agreement, share these rights? We can diffuse a lot of these issues. If we wait for the law to give us an answer, remember I said 20 or 30 minutes ago, don't look for answers? Yeah. The problem is that's the job of a court. The job of a court is to decide cases, which means in the end, if this goes to a court, you're going to get an answer. And there's a high likelihood, no matter who you are, no matter what you want, you are not going to like that answer. You're just not going to like it. We need to get away from all or nothing. We need to share rights, and we need to preempt the, I think, exploding issue of work for hire that's waiting out there to be litigated.
Well, that's really terrific advice to end with, Kenny. That's fascinating. I hope I'm speaking for all of my colleagues in thanking you tremendously for the contribution you've made to this course in a number of ways, but especially for your time over the past hour and a half to talk with us.
My pleasure. I want to thank all of you for being great colleagues. I want to thank everybody out there who's watching for your interest, your ambitions, your activism on these issues. Please be involved locally, nationally, internationally. Please be involved. Make your voice heard. And I want to really thank you for this invitation. You invited me personally, and for inviting the use of my book. I'm honored and flattered, and I hope that the readers out there found it useful. Thank you.
Thank you, Kenny.
Thank you, Kenny.
Thank you.
And I hope that Rebecca is going to tell us how we get out of this now.
It's like one of those awkward moments on TV where we all just
Exactly. Well, we'll stop the broadcast now. Thank you all so much.
Thank you.